Hi, very good morning. This is a Delhi High Court judgment under Goods and Service Tax Act. Citation is Puneet Batra versus Union of India. Issue is search of advocate office by GST authorities, Anti Evasion wing, whether it is legal or not. That is the issue. Facts. PB is an advocate by profession. His parents have a legal firm, consultancy firm, a limited liability partnership firm, and PB is the advocate handling all the taxation matters of that firm. One of the clients by name Mart Karma Technology Private Limited. Hereafter I will say client. Avail the services for its legal matters, including filing of returns of GST, filing of returns with the registrar of companies, income tax returns, and all the work, almost all the work. It has entrusted to the advocate and they were availing the services. You can say complete service. A search was conducted at the client's premises, that is, Mart Karma Technology Private Limited premises, by the GST authorities. The advocate was handling more than 100 cases of the client, including this search case. The advocate tried to contact the client. Maybe he wanted to take some information to give it to the authorities, but there was no response from the client. Hence, he withdrew its wakalat, which was filed before the GST authorities. Then the anti evasion wing of GST issued summons to the advocate. You appear before us. He appeared before the anti evasion wing and filed a reply stating that I am only a lawyer, I am only handling their cases. Then, after this reply, the anti evasion wing issued four more summons to the advocate. He did not appear for three summons, and for the fourth summon, he appeared and recorded his statement. Anti evasion wing, they suddenly conducted a search at the advocate office and seized various documents, electronic gadgets, and the complete CPU that was there in the advocate office. A panchnama was also given, a statement containing what are the materials that have been seized. A further summon was issued to the advocate to appear before the authorities. At this point in time, immediately the advocate filed a writ petition before Delhi High Court, challenging the summon issued to him. High Court, by way of an interim order, directed the department to file its stand. What is your stand on this issue? You file it by way of an affidavit. It directed the department. The High Court also directed that the CPU, which was seized from the advocate office, it shall not be opened without the presence of advocate or his authorized representative. Interim protection was given. Then, in the next date of hearing, department submitted that the advocate was not merely representing the client as an advocate, but he was also involved in running the business of the client. The department submitted a note in a sealed cover with a lot of documents and statements. This was objected by the senior counsel appearing for the advocate. They said, no, no, this kind of a sealed cover, this thing should not be given. You should give all the documents to the petitioner, that is the advocate, and he should be given an opportunity to rebut the version of the department. That was the submission. At this stage, department submitted the original file before the court, which contained reasons for investigating the advocate. The department submitted that revealing all the statements recorded from various persons that will jeopardize the investigation, and the statements recorded show active role of the advocate in the business of the client. So Delhi High Court uh, said that GST officials They are not permitted to open the CPU or computer of any advocate without his presence or consent. So I repeat, Delhi High Court said that GST officials are not permitted to open the CPU or computer of any advocate without his presence and consent. The same will lead to serious breach of attorney-client privilege protection. So if you open the CPU of an advocate, you get all the details. That will amount to violation of attorney-client privilege. The court cautioned the GST department, unless exceptional circumstances exist and subject to further orders that may be passed by this High Court, that is Delhi High Court. If any advocate's office is to be searched or computer to be opened, the same should be done in the presence of the advocate and not otherwise. So you cannot open without the presence of the advocate. Court permitted examination of CPU in this case. In this case, court permitted examination of the CPU in the presence of the advocate and two lawyers. Further directions also they have given alternatives. Forensic expert of GST department, some IT officials of High Court. Everybody should be present, and in their presence it should be opened. So some other directions are also issued with regard to extracting data from the CPU. Other detailed instructions were also given to the department for collecting and analyzing the data. The court also directed that no coercive step should be taken against the advocate in this case at present. The case is posted for further hearing after all this is done. That is where the case stands. My comments, it is a sensitive issue. Just because I am an advocate, I am not going to say department should not conduct search by advocate's premises. It's a sensitive issue. So that what I feel is there is a Lakshman Rekha which both the advocates and the department should not cross, whether it is income tax, whether it is police, or whether it is GST department. That is Lakshman Rekha. Both of them have a Lakshman Rekha. Nowadays, what I see, it has become very common for some tax consultants, advocates, and chartered accountants to do all the acts, including raising of bills, filing of return, maintaining accounts, everything, the whole operation of the client. They take care of it, so that the purpose is they have a complete control over the client. The client will not go to some other advocate or chartered accountant for consultation of any other matter. Everything is taken care of the same advocate or chartered accountant or tax consultant. Many firms I have seen personally, they hire BCom graduates or CA inter students. Like they pay them a meager amount, and they use them for all these purposes. So the client is in their fold always. This seems to be the basis of the problem, in my view. If advocates who are involved in business, suppose I am assuming this, if advocates who are involved in business cannot be searched or questioned, then all the evaders, tax evaders, what they will do is they will prefer to keep the books in the advocate's premises. So this is my view, and this my view has no connection with this present case. I am just generally commenting on the prevalent model of profession which is happening in the world. That is what I am commenting. I am not commenting on either the advocate, their advocate's firm, or the search conducted by the authorities, whether it is correct or not. Even High Court has not given a final view on this. So my comments are general comments. That's what I want to say. Thank you very much. Have a great day.